My name is Tamer Elshimi. I'm with Thurber Engineering in Edmonton, and I will be the moderator for today's webinar. Today, I will be moderating Bill Kenny of Kenny Law, who will be speaking on recent developments in the law as it applies to underground construction and limitation of liability for unknown risks. Before we start here, if anyone has a question during or after the presentation, please use the QA button at the bottom, and we will address them at the end. So just before I introduce Bill, this webinar series is presented by the Canadian Underground Infrastructure Innovation Center, or CUIIC. This is a bi-weekly webinar series which started in September, and it will be running until December 8th. We also are planning more webinars, seminar, and courses for the 2023. And you can see all the details on CUIIC's website, www.cuiic.ca. So what is CUIIC? CUIIC is a cross-Canada hub for research and education in underground infrastructure. It is located at the University of Alberta. CUIIC is a membership-based organization that involves stakeholders, including municipalities, contractors, owners, consultants, and others, to identify pressing issues facing the underground sector. CUIIC stakeholders represent all underground infrastructure domains, including water, wastewater, transportation, gas distribution, energy, power, and telecommunications. And the idea with CUIIC is to bring all these sectors together because we all face similar challenges when we are dealing with any kind of construction or maintenance of underground infrastructure. So we can learn from each other and work better with each other. As I mentioned earlier, CUIIC is membership-based, and it is open to manufacturer, suppliers, contractors, consultants, utilities, municipalities, and nonprofit agencies. And you can also become an official research partner with the University of Alberta. And that was the idea of having CUIIC based at the university, so we can use the university to build on the research that the industry sees as being required. There's also CUIIC Connect groups and forum for online discussions. And again, this is a cross-Canada discussion. There are more information on the membership on the website if you are interested. Okay, now to the webinar. So today's webinar, recent developments in the law as it applies to underground construction and limitation of liability for unknown risks, will be presented by Bill Kenny. Bill acts as a general counsel practicing civil and regulatory litigation and construction law, as well as transportation, insurance, and corporate commercial law. Bill has acted for contractors, consulting engineers, and owners, and has experience in all forms of claim-related events and dispute resolution, as well as the preparation of contract documents. He has also been appointed as arbitrator and mediator in many commercial disputes. In 2019, Bill was recognized for receiving an AV rating in the LexisNexis Martindale-Hubbell peer review rating for the past 20 years. Bill was recently ranked by Lexpert as one of Canada's leading infrastructure lawyers for 2022. So thank you so much, Bill, for your time today. And yeah, please take it away.
Okay, thank you, Tamer. I'd like to talk to you today about some of the legal concepts that apply to underground work, particularly as they relate to, or perhaps with emphasis on, soils conditions. Much of the legal jurisprudence in this area is not necessarily new, and I'll comment on that in a minute. But it now is overlain by a more recent development in the concept of good faith in contracts in Canada. Again, this concept is not entirely new, but it's certainly now entrenched and refined and applied in 3 recent decisions of the Supreme Court of Canada, the most recent of which came out less than 2 years ago. So you might ask why there's less judgments or less jurisprudence actually on the issue of soil conditions, and that's because most construction disputes today are arbitrated, and we don't get decisions in arbitrations because arbitrations are generally considered to be private, and there's no jurisprudence that develops as a result. The benefit, of course, of arbitrations, particularly to the consulting industry, is that in an arbitration can only be between parties to the contract, and no one can be third party. So that if a contractor sues an owner cannot third party the engineer. If the owner sues the contractor, likewise, the engineer cannot, or the consultant cannot be third partied into the action. Certainly, I believe or suggest a benefit to the consulting industry. So let's just talk about subsurface conditions, and you'll see the first slide. They're sometimes called subsurface conditions, sometimes concealed or unknown conditions or hidden conditions, and they all engage the concept of the allocation of risk from the difference between the conditions that may reasonably be assumed to exist based on available information and actual conditions encountered. And that's the kind of language you'll see in most of the contracts dealing with difference in conditions clauses. Some contracts will provide relief for a difference between what could reasonably be expected to be encountered at a site and the actual conditions encountered. This is not common. In my view, it's not recommended because what can be expected to be encountered has an element of subjectivity to it, and it's always a matter of argument. So what is the obligation then of disclosure, and how can liability be limited? We'll go to the next slide, Tamer. The consideration, I suggest, starts with the basic premise that an owner has no obligation to investigate subsurface conditions, and therefore no need to provide information to prospective bidders or anyone else. That would apply if you had a greenfield site, there was no investigation done, you hired a design build entity, and you provided them with no information and allowed them full time to do investigation. However, that's not realistic. An owner is not going to build on a site without investigating to determine if that site can accommodate the development that is intended, and no engineer or design professional will provide advice without a proper investigation. So as a result, an owner is going to gain knowledge and understanding, data, opinions, information about the conditions that can't be observed, or the concealed conditions. And this allows the owner to assess the feasibility of the intended development, and then the owner's obligation to disclose is activated. Next slide. I want to talk to you about the legal concepts that apply to this. In Canada, we have concurrent liability for breach of contract and liability in tort, and both are for actionable misrepresentation and actionable non-disclosure. And you might ask, why is this relevant? Well, it's relevant because not everybody that may assume or may acquire or may have liability on a site is a party to a contract. An engineer has been held to potentially have liability to a contractor for design documents where there's no privity or no contract between the engineer and the contractor, the engineer having done work only for the owner. That is liability in tort. And so the problem becomes how for such a consultant to protect themselves from liability from persons with whom they do not contract. But we start by looking at the contract, always looking at the contract, and you can look at it to see whether there has been a breach of express terms, a breach of implied terms, or a breach of the obligation of good faith which I referred to earlier and we'll deal with in more detail. Then there's the concurrent liability in tort. And tort is simply where the law provides compensation for injury. A tort is simply an injury. Not all injuries are compensable, but certain ones are, where there happens to be a sufficient proximity between the person to give rise to a duty, then you can have liability in tort. It's not indeterminate, and it applies generally only where there has been physical damage, except in the case of negligent misrepresentation where no physical damage is required. So in tort, liability in this area generally centers on negligent misrepresentation or indeed in deceit. The negligent misrepresentation, of course, can be in the design, it can be in a report, it can be in test results, it could be in logs and data that are not properly recorded. It can be in summaries that don't disclose all of the information available. Just so to take a minute to say that in these kinds of cases, when you get into litigation, all documents that are relevant and material are required to be disclosed, and a discovery process will enable pre-trial examination of all of those issues so that whatever information was available and potentially not disclosed is subject to being revealed. Next slide. So where you have a properly worded clause excluding liability in a contract, contract trumps tort, and you do not have, even though there's a concurrent liability in both, the contract will limit the liability both in contract and in tort. The problem, as I said earlier, is where the party is not a party to the contract itself and is being pursued with someone and does not have the protection of a contract. You should also know that in the case of civil fraud or deceit, an exclusion clause provides no protection, and it will provide, as I say, no protection, and it will have no application in that case. So we'll go to the next slide, and I want to talk here about the fact that contracts often contain express warranties. So we'll talk about express terms first. An example of this would be the availability of borrow material, the quality, the quantity of borrow material, the properties of the borrow to be expected to be encountered. These apply to soils conditions issues. As-built drawings, for example, of an existing site are an express representation of the actual conditions to be encountered. And if they do not disclose that is your as-built drawings, actual conditions of a site that have been observed previously, including underground conditions, that is a breach of an express warranty or representation contained in the contract and actionable against the party who has published those as-built drawings. So whatever is in a contract must be delivered. Next, an example then of an implied term is a term, for example, that the owner does not have possession of material information that's inconsistent with or contradicts the information in the tender documents. Often you will see, and it is wise for a contract to exclude the implication of terms. A term to be implied, it can be a term that's necessary to give commercial efficacy to the contract, but it cannot be inconsistent with anything that's written in the contract itself. Next slide. We'll then talk about this new and developing concept of the obligation of good faith. The Supreme Court of Canada has described it as an organizing principle applicable to all contracts. It may be circumscribed, in other words, somewhat limited. There can be a collar put around it by a contractual limitation, but it can never be excluded. Good faith applies and is an organizing principle to all contracts in Canada. And what does it include? Well, it includes a duty of honest contractual performance. And that includes a duty to correct a misapprehension. One certainly can't lie, one can't mislead, but also to correct a misapprehension. But more importantly, it's a duty to exercise discretion given by the contract reasonably so as not to deprive or the opposite party of their reasonable commercial expectations. So that if there's a clause, for example, that if there's a report of a substantial difference in soil conditions, then there can be a consideration either by the consultant or the owner to determine if in fact that's the case. That is a discretion. And that discretion must be exercised reasonably, and it must not be exercised so as to deprive the other party of their reasonable commercial expectations. Next slide, please. This obligation of good faith, as I indicated, has developed through a trilogy of 3 recent Supreme Court of Canada decisions. The first came out in 2014 in a case out of Alberta and dealing with a renewal of a franchise. And these cases have developed this theory and applied it to the performance of the contract. But there's no principled reason why it will not be applied to pre-contractual representations which result in the contract, such as including questions and answers exchanged during a bid period, to which a full answer must be given. Actionable representations, both in contract and in tort, but actionable representations in addition to the express representations in a contract or implicit in the express representations, and so these would be actionable representations in tort, can include a statement of opinion, an opinion which constitutes a representation of fact. And so an opinion is not somehow exempt from consideration of being actionable, where it is expressed as actually a representation that this is what you may expect. This is a representation of fact. There can be misrepresentations by omission, where there is a duty to speak and the omission renders the representation incorrect. That is always, the duty to speak is always called upon if there's actually a contract between the parties. But if there's proximity between parties, in other words, where the person who's receiving the representation or the omission is a person that could be expected to rely on it, they would be within the proximity where the law imposes a duty which becomes actionable. And so that, as I said, an omission then, because there would be a duty to speak, could result in liability. Silence itself, amounting to a positive assertion that certain facts did not exist or create a false impression, can be an actionable misrepresentation. Failing to answer accurately a direct inquiry from a tenderer or a contractor. Failing to correct a fact honestly represented when it becomes known the fact is no longer accurate. So when a fact has been represented and there's continued reliance on that fact, and it turns out that it is determined to be incorrect, there is a duty and an obligation to correct it. Next. Now, the innocent party must also show reliance on the misrepresentation in order for it to be actionable. There must be entitlement to rely on it. That is, it must be only those persons intended to rely on it, not the general public. and that reliance must be reasonable. In other words, if the party could, by the exercise of their own reasonable diligence, have determined the actual facts, then perhaps the reliance was not reasonable. So as I say, there must be reliance, entitlement to rely, and it must be reasonable reliance. So once some of the information has been provided, an owner provides some information. Some is provided, there is an obligation to make all information available. Selective disclosure, I suggest to you, is perilous, withholding information even more so. So if you're going to make disclosure, as you're going to be obligated to do, all information, in my opinion, has to be disclosed, and you cannot be selective. Recall also that a consultant retained by an owner is acting for that owner, and their information becomes the owner's information and actionable against the owner. Let's turn to the next one and talk about limiting the liability. As I said before, liability, save for deceit, and the obligation of good faith itself can be limited by contract. You can displace the obligation, displace liability in tort by saying that it can't be relied on, and therefore the reliance is not reasonable, and liability in tort can be limited. But the limiting clause will be scrutinized carefully, and it must cover the situation that's encountered, although the law has become a bit more receptive to understanding that these kind of clauses are simply an allocation of risk, and therefore recognize that all clauses must be given their ordinary meaning, whereas years ago you used to hear that they would be interpreted only against the party that wrote them into the contract. And the true meaning is gleaned from the whole of the contract, its commercial purpose, and the matrix of facts pointing to the intent of the clause. In other words, limitations, exclusions of liability for things like reliance by an engineer must be given, or a consultant must be given their ordinary meaning, because no consultant that earns a fee can take a risk of liability for the consequences of a project being delayed and loss of profit resulting from that. That is simply not a commercial reality, and that kind of clause must be given its ordinary meaning. So reliance on a consulting report or an engineering report can be limited by appropriate admonition of non-reliance. That is saying that it can't be relied on by anyone other than the party procuring the report. And with respect to the party procuring the report, there can also be a limitation, and the limitation can take several forms. Not likely can it take the form that you can't rely on the report, because that's the very purpose for which it's being obtained. But liability can be limited in amount to the fees that are being incurred, to a specific, or being paid, to a specific dollar value. And there are other ways of limiting it reasonably to allocate the risk, which, as I say, cannot be taken for certain amounts. For an owner, in my view, the best practice is full disclosure of all data, information, and information without interpretation or an opinion, and with the admonition that all users are to draw their own inferences, conclusions, and observations, but make the information and the data available. And the interpretations would be that of their own, but the information itself, you're going to have to stand behind, in my view. Although parties do try and say, I'm giving it to you, but I'm not giving it to you for you to rely on it or to use it, which to me is an inconsistency to such an extent that it really defeats the whole purpose of providing it. I want to talk about immunity from liability for a moment, and this is by the Limitations Act. Liability for breach of contract and tort and I'm talking about Alberta, I'm talking about Ontario, limited to 2 years from the time that the claimant knew or should have known they had a right to claim against the person who was liable, that the claim merited bringing an action, and that it merited bringing an action. Then there's a 10-year drop dead date in Alberta from the time the duty arose. It's 15 years in Ontario. To give you an example, some years ago, a house fell into the river in Edmonton. The city was sued, as well as some of the consultants. It was found that what had happened in the design had happened more than 10 years ago, and while there would have been liability found, despite the fact that it could not have been determined within the 10 years, despite the fact that this meant that the party whose house fell into the river couldn't have known within 10 years, it was still barred by the statute of limitations, the ultimate drop dead rule. These limitations, do not forget, apply equally to arbitrations. An arbitration must likewise be commenced within the 2-year limitation and the 10-year limitation. I won't take a lot of your time because we don't have much dealing with consequential damages, but I want to just warn you that consequential damages is one of the most misused legal terms that we have. Gaining some jurisprudence in Canada as to what it should mean, but still very much controversial. What you want to do is limit damages for such things as loss of profit, loss of continuing overhead, and similar types of loss. Those are not necessarily consequential damages, although there may be some jurisprudence suggesting that's the case, because a loss of profit from a building that's being built for the sole reason of earning a profit is a direct loss, not a consequential loss. And so saying that it's consequential loss, including loss of profit, has in some cases been interpreted to mean that it's only loss of profit which you couldn't foresee and which wasn't direct. Very controversial. So you're better off to limit it to loss of profit, loss of continuing overhead, and losses of the similar kind. And you can limit it to consequential as well, but be very careful not to just be lulled into saying we exclude consequential damages and thinking that you're protected. I included in the slides an example of a limitation clause for consequential damages. I did not include a clause saying that there should be no reliance on a consultant's report. That's something, though, that you should consider and have readily handy. And I also included a clause, this comes out of one of the CCDC contracts, dealing with concealed conditions and the usual clause. I don't think there's time, nor will I spend any time dealing with these. Tamer, I think I've used up pretty well all my available time, or all of the available time. Is there any questions you want to deal with?
Oh, that's great, Bill. Thank you so much. I don't see any questions in the QA sessions. If you have any questions, yeah, please feel free to add it in the QA section at the bottom.
Well, that was either so clear or so confusing that nobody has any questions.
There are some hands up. I guess there are 2 hands up. Tarek? Can you please add your question in the QA box if you have a question? Oh.
Jurisprudence, the question is, explain the meaning of the term jurisprudence. In the common law, we have statutes and we have case law, and if a case is decided and it determines things like when is a duty owed by a consultant to a party with whom they do not contract. The cases that are decided, particularly as they go up to the Supreme Court of Canada, they will make the law that will circumscribe or determine when that duty is owed, or what is a duty of good faith, how is it to be applied. It is those cases, those common law cases, which become binding law, which are known as jurisprudence, as I've referred to it today.
We have a few questions here in the QA section. Bill, can you see them?
I can see the top one that says ASC 3822 talks about underground utilities. So in other words, interpreting the quality of the information seems this may be a good idea. Not sure what the answer to that would be, but the quality of the information, the interpretation of it should be up to the party that's reading it, unless you want to express your opinion on it as a matter of fact. But if one does, one must stand behind that opinion, in my view.
Okay, there is another question in the chat section from Ryan.
If an owner says you are not to rely on subsurface information or reports provided and that a contractor must conduct, but then prevents the contractor from conducting such, is there a precedent set for this type? A dim view is taken of the suggestion of doing one's own investigation, but preventing one from having the time to do it. And most subsurface investigation, it's impractical to do within the bid period. First of all, the site is unlikely accessible, nor can it be accessed with the kind of equipment necessary to do the test. And so suggesting that one must conduct their own investigations when there's no practicality to do so is going to get a very dim view when a court looks at it. And I would suggest that if you're going to, as an owner, say a contractor is to conduct their own investigations, then you better ensure that the site has been made available, that has been made available for a sufficiently long period of time, that there's no requirement for permits that are going to inhibit a contractor doing so, and that the requisite equipment can be brought onto the site to do it.
Okay, great. Good questions. I don't see any more questions in the chat or in the QA session. So I guess that would conclude the webinar for today. If you have any further questions that you would like to follow up with Bill, here's his email address. You can please feel free to do that after the presentation, after the webinar. In the coming webinars here for this year, we still have three webinars in November and December. Difficult ground conditions, trenchless contractor perspective on November 10th. We have Journey Towards Reconciliation as an Engineer on November 24th. And we're gonna conclude with a presentation by Dr. Ian Moore from Queen's University on December 8th. And as I mentioned, there will be more webinars and seminars planned for next year. So thanks again, Bill. That was great, and thanks everyone for attending. And please check CUIIC's website for the upcoming events. And yeah, have a great day.
Thank you.